Bill C-2 is being promoted as a crime and security bill, border security bill, but it includes sweeping measures that touch on Canadians' private lives. In a data-driven world, it is of utmost importance that governments, citizens, and companies have the fundamental right to privacy protected. The issue with Bill C-2 is that it touches on so many details without enough language or safeguards in place to properly study each component in a way that serves the best interest of Canadians or the implications of the new language contained in this omnibus piece of legislation. While there are many parts of this bill that could be critiqued, I will focus on the privacy side. This is particularly important to me because in the last Parliament, I had the privilege of working on Industry Committee on Bill C-27, which attempted to update Canada's privacy laws. In that process, we sought to enshrine a fundamental right to privacy in legislation. We sought to establish world-leading protections and safeguards for children. We sought to define and limit the socially and commercially acceptable use of personal data. And we sought to strike a fine balance between commercial interests and the right of personal data to be protected under the ownership of its user. I can't help but think of the relationship to C-2 and the sweeping powers it seeks to provide government that we sought to protect in the last Parliament. So, in my opinion, the Liberals have taken this opportunity to develop a secretive, sweeping surveillance regime into a bill that was supposed to be about border and crime issues in response to the tariff challenges we faced from the United States. With that context in mind, let me turn to the specific parts of Bill C-2 that warrant, in my opinion, further study on privacy concerns and are of greatest concerns to my constituents and experts alike who have written my office. Let's look at Part 14, an amendment to the Criminal Code under information demands. Part 14 creates a new law that lets police make information demands. This means police could ask internet or phone companies whether someone is a subscriber, even without a warrant. The standard for doing this in the legislation is very low. Police only need to have a reasonable suspicion. The Supreme Court has already said that's not enough when it comes to people's online account information. So that, in my opinion, may go against two very important recent Supreme Court decisions. In R versus Spencer, the Supreme Court ruled that Canadians have a right to privacy in their internet account details, and police need a warrant to access that information. In R versus Boykovets in 2024, the court made it clear that even things like IP addresses are private and also need a warrant to access. Part 14 would let police bypass these privacy protections. Part 15 of the Act, Supporting Authorized Access to Information Act. This creates a new category of electronic service providers and designates certain core providers. These companies would be forced to build and maintain technical backdoors at the request of law enforcement, allow law enforcement to test direct access to their systems, and keep all such requests secret from the public. Think about the implications of that. The government can tell a telco, an internet company that they're going to do things in private with people's personal data and they don't have to inform the public. This has massive implications that need to be examined carefully. Part 16 of the Act rewrites Canada's privacy and financial rules. It touches upon the proceeds of crime, money laundering, and Terrorist Financing Act under sections 11.71 to 11.73. It creates a new part 1.2 of this law, allowing reporting entities such as banks, credit unions, and money services businesses to collect and use personal information without an individual's knowledge or consent if the data is provided by the government or law enforcement for purposes related to anti-money laundering, terrorist financing, or sanctions evasions. I will note in this request that we do need to improve this bill, but without some of the safeguards that Conservatives and even Liberal members were trying to establish in Bill C-27, it opens the door to future abuse and misuse by law enforcement agencies if these definitions and concepts of privacy and data are not modernized in Canada. Secondly, Personal Information and Protection Electronic Documents Act, Section 7 and 9. Under this portion of Part 16, it introduces exceptions so that the usual requirement for knowledge or consent no longer apply when collection or use is under the above provisions, namely the Terrorism and Financing Act. It also removes the obligation for individuals to access their own information if it was obtained under these rules. Essentially, this is allowing for banks and financial institutions to use Canadians' financial information without consent when the government supplies it. Think again about the implications this will have with the Canada Revenue Agency and financial institutions and the privacy of individuals, what this could do to the makeup of families, secret information or information that they want to keep private from other family members, not for criminal purposes, but maybe for business-related purposes. We have privacy in Canada for a reason. This law undermines it. I should say this bill undermines it. Part 11, cash transaction restrictions. Constituents in my community have raised concerns about the provisions related to cash transactions. Now, I know in many cases, in British Columbia especially, we have to, at casinos, at car dealerships, cash transactions have been abused. But there may be a better way that's outlined in this bill about how we treat cash moving forward. We have to think about the context of religious organizations who collect large amounts of cash at a weekly service at a Gurdwara or at a Christian church. We have to look at charities and auctions and the application it will have in those aspects of our society. And then finally, Madam Speaker, I would be remiss if I didn't quickly touch upon the Canada Post Act amendments. The Liberals think giving the ability of government to open your mail under very spurious grounds will serve Canada's interest. I would argue that we can find a middle ground. We can apply technology. We could speed up the use of warrants where necessary so that law enforcement does indeed have access to drugs that are mailed, such as fentanyl, in the Canada Post system. So in closing, Madam Speaker, this bill is litigation in action. I just can't imagine the number of court cases that are going to come from this legislation if we don't address these major privacy concerns, if we don't get the definitions correct, if the government is not very clear about the safeguards and the application of the things that they're proposing, which go well beyond everything they promised in the election, and in a way that Canadians aren't even aware of. This legislation needs careful scrutiny, Madam Speaker. So if this bill passes, I would encourage the minister to critically review whether the privacy and data collection aspect is even necessary for its core objectives about protecting our border. Now, coming from a border town, we want strong infrastructure at our border. We want to see more CBSA officers enforcing existing laws. We want to see the equipment and the military presence where necessary to keep Canadians safe. But this legislation goes well above and beyond the Canadian consensus about what we need to do to keep people safe today. Thank you, Madam Speaker.